All right, so to help me unpack everything we just learned this morning, we have criminal defense attorney Patrick McDonough with us, also a former district attorney. Patrick, great to see you again. Thank you for being here.
Thanks for having me.
Okay, well, since we just saw the opening statement delivered by the defense, why don't we unpack that first? Because we talked for a while with CourtTV legal correspondent Chanley Painter before we went to break. So let's focus on what was said here, and that was a pretty brief opening statement that was delivered. What stood out to me were a few things. It seemed like the major points he wants to get across to this jury were that there may have been things that were wrong, immoral, things that they won't really like to hear, but that none of it was illegal. That it seems to me that he's putting forth, hey, this seems to be something that's consensual. That's where we're going to go in terms of a defense here. Your thoughts, please.
Yeah, that appears to be the theory of his case. And I don't know if that theory, based on kind of this mountain of evidence, is necessarily a bad theory. I was a little shocked and a little surprised that he didn't do more about his client and tell his story a little bit more and build that up. It almost sounded like he was the prosecutor at times talking about his infidelity. Now, I mean, I understand the point of we're going to admit when we do something wrong, but I thought he missed some opportunities.
Right. Okay. Anywhere else you thought he was lacking? Anything in particular? Maybe you would have done differently had you been the one defending Kellen Winslow II in the case.
Yeah, I think he really should have spent more time trying to explain to the jury that they've really got to look at each of these Jane Does individually, almost like they're an individual trial.
Sure.
That what happens is everything gets thrown together and it sounds really bad. But really, they have got to prove the state beyond a reasonable doubt each and every one of these cases, right? And they all have problems individually. There's all different ones. Some of them don't make a proper ID. You know, some of them really can't see what was happening. Some, I think there was 2 that didn't make a proper ID. And I think he should have spent a little bit more time trying to lay those seeds of doubt with each of those cases and trying to make sure the jury would focus on each of the people individually and whether the state actually met their burden.
I gotcha. I understand what you're saying. Well, let's kind of unpack what he said here. I took some notes as he was speaking, and something that stood out to me when he was speaking about Jane Doe number 4. He said his words, "Sure enough, here comes Jane Doe number 4." And he said this was after there was lots of news coverage. So he seemed to be pointing at the news coverage as the reason that this alleged victim came forward, saying that she was raped.
Right.
Any thoughts on that?
Yes, and I think once it got out in the media, that's going to be part of their defense strategy, right? That there's people that he's famous, there's people that want to be famous, even if it's not a civil case, so they're trying to make money. They want their kind of day in front of TV or in front of the court. And so I think that is actually a very good point that he made out. Once this came known, that's when these other people started showing up.
And he seemed to do the same thing with respect to Jane Doe number 5. His words, Jane Doe number 5, created by the media, saying she never saw anything, never saw the other guy in the jacuzzi, said that the news story about Kellen Winslow II was playing in the gym at the time, saying that she freaks out over the foot touch because of what she was seeing on the television.
Right, and you can see that, right? What he's trying to say is she's already thought, oh my gosh, I'm around this predator. She's scared of this person, really not knowing any of the case. And so she's jumping to conclusions, right? She's creating things in her mind that she doesn't really see. What does she see under the bubbles? And she's missing big things like people that are actually in the room. So I think that was effective.
Sure, agreed. And we're going to talk a little more about the defense opening statement, but what we want to do right now is take a look back at what the prosecutor said in part in his opening statement.
You will learn over the course of the next few weeks that Kellen Winslow took what he wanted. He took what he wanted, not from 1, not from 2, but 3 women. He victimized 5 women.
All right, there you hear the prosecutor saying that Kellen Winslow II took what he wanted, victimizing 5 different women. Okay, so his theme, if you will, seemed to be that this man has been given much, but it wasn't enough. He kept taking. Thoughts on the prosecutor's opening statement?
So I think substantively the prosecutor did fine. They laid out everything. They went through each person and they laid that out. Stylistically, I was a little surprised. I mean, if I was a prosecutor, I wouldn't be talking about a taking. I mean, that sounds like a theft, right? This would be a rapist, an exhibitionist. I mean, this was horrific things that happened to these women, and there wasn't much of that passion in there. So that was, to me, was a little surprising. Even when he talked about what happened, there wasn't a lot of painting the scene, trying to put the juror right there. It was much more kind of a methodical checklist of the things. Now, ultimately, he has a mountain of evidence, so I think probably okay and going to be successful, but I thought you could have lost the jury a little bit.
And how about, he talked a lot about Kellen Winslow II's deeds and judging him by his deeds. Let's go back and take a look at that clip. Then I want to get your thoughts, please, Patrick.
5 women, unknown to each other, barely known to the defendant. All of them have come forward to tell you about his deeds. And I ask you to judge him by his deeds, not who he is and not who his father is.
All right, and what we just heard was at the outset, but then at the end he wrapped it up and reiterated that again, which I thought an effective tactic in saying that, look, we want to take the celebrity out of this trial, focus only on the evidence. Your thoughts?
Yeah, no question. I mean, he comes from a great family. He's famous, seems to be loved in that community. His father was loved in that community. So clearly what they're saying is, please set that aside and let's look at what happened. And really that line of 5 women that don't know each other all coming forward, I mean, that's powerful. And that is difficult for the defense to overcome. We're not talking about like 3 girls or women that were together that knew each other, that, oh, maybe there was some conspiracy here. These are 5 different people that all came together with really kind of horrifying stories.
And Patrick, you've been a district attorney, you've served in that role, and now you practice criminal defense. You're a great person to ask this question of, seeing that you know how to approach a case from both sides. I feel like it would be very challenging from an advocacy standpoint to try this case if you're the prosecutor, because you have these 5 different stories, and really they're all separate, and this case has been consolidated. And so to effectively tell the story for the jury, he had to go through each one individually. That could be tough. I've thought a lot about how they might frame this case. What do you think as far as how he did from an advocacy standpoint in terms of telling the story effectively, getting the jury to understand what they're going to see ahead with the evidence and the testimony?
I think he did a good job substantively. I think he did go through each of the cases and he methodically went through all of the evidence, which is a lot of evidence against the defense. Again, stylistically, I thought it could have been more of a story and there could have been better transitions, and you could have talked about like being there on the side of the road while things were going by and the wind in your face, or being blind and being attacked, and bringing some more emotion to it. I think he could have drawn the jurors in a little bit more. But the 5 people, though, it's hard to cover a lot of territory. At the same time, right, that adds a lot of credence to everybody. If they're all individual, you can poke holes about one person. But at some point, if you're always explaining from the defense side, you've got challenges.
Sure. And I think one challenge certainly is to speak to the jury, introduce them to what they're about to hear. And much of it is very graphic, and to say it in such a way they're going to understand it. And we want to warn you, the clip we're about to play does contain some language that is graphic and a description that's very graphic. Let's take a look back at something else the prosecutor said in part, please.
The pain that she felt was so tremendous that she said she felt herself begin to bleed. That it was when she began to bleed, and she was not menstruating, but that as she began to bleed, the defendant just stopped. She thinks that may be why, but ultimately when he stopped raping her, he told her to get out of the car.
All right, that was with respect to Jane Doe number 1. Certainly not easy to give that kind of a description to the jury, and we're talking about 3 alleged forcible rapes here in this case. Your thoughts about how the prosecutor handled that?
Yeah, it's difficult information, right? And it's very painful. I think that was one of his better spots, though. I think he embraced it, he told it like it was, and you could actually almost put yourself there thinking like it was so bad, like she could feel herself bleeding. I mean, that is powerful. So I thought that was one of his better spots in the opening.
Patrick McDonough, thank you so much for your thoughts, your expertise. We're going to ask you to stay with us, please, here in the studio. We need to take a quick break right now on Court TV Live. When we come back, we're going to go back out to San Diego and get a live report from our Court TV legal correspondent, Janley Painter. Welcome back to Court TV Live. I'm Julie Grant. Thank you so much for being with us on this Monday. So court is in recess until 9 a.m. tomorrow. We heard the opening statements from both the prosecution and the defense in the case of the state of California versus Kellen Winslow II. Now we want to head back out to San Diego, where we find Court TV legal correspondent Shanley Painter to help us unpack what we heard from the defense. Shanley, first thing I want to ask you is, I want to hear about what the jury was doing as they were listening. What did you observe from the members of the jury, the note-taking, etc.? Tell us what you saw, please.
Yes, they're very much attentive, sitting there watching the defense attorney, Brian Watkins, who seemed to move around the courtroom a little bit more. He walked over to the defendant. He pointed out his father. He really grabbed the attention. He didn't have the visual element that the prosecutor did. He kept it pretty short, which was surprising. He just basically talked for about 15 minutes or so and summed up what he could, the best he could, and then now the jury is free for the rest of the afternoon. Court is dark this afternoon. They'll be back tomorrow morning to begin with the first witness from the prosecution.
Shanley, something that I found to be very effective from an advocacy standpoint is when Brian Watkins walked over to his client, to Kellen Winslow II, and put his hands on his shoulders and talked about how he's lived a really uncommon life and been in the spotlight since he was young, and said that people often want things from you when you're in the spotlight. Talk to us about what you saw, what you observed, what the jury was doing when that was going on.
That was probably the biggest moment of the the opening statement was where he walked over and put his hands, because the prosecutor spent about an hour showing pictures of Kellen Winslow at various parts of his life. And then, so the defense just walked over and said, here he is now, here he is today. He grew up and in the spotlight. He even turned and pointed to his father, who's sitting in the gallery almost behind the defendant, and said, look, he grew up in the spotlight, and that makes it difficult. It's difficult to grow up in the spotlight. People want things from you, insinuating that these victims maybe have a motive for claiming a rape, when the defense says these were extramarital affairs. He's not a perfect man, and you're going to have to set that aside. He asked the jury, to whether they like it or not, that he's been unfaithful to his wife. He set that aside, and based on the evidence alone, listen to what you don't hear, is what he said. Listen to what you don't hear in this case, and then find him not guilty. And that was basically it, short and sweet, to the point.
Right. Yeah, he was. He certainly was short and sweet with his opening statement there. And it's something interesting. I want to kind of piggyback on what you said about the lack of evidence. He was saying pay attention to the lack of it, and said that we wouldn't be hearing about injuries to indicate that this was forcible conduct. He was saying this is conduct that's wrong, it's immoral, it's extramarital, not even, he said, I won't even dignify just calling it affairs, just sex, no strings attached. But I thought that was interesting. It seems to me he's going to pick apart those exams and the medical results from those exams.
Right. Their defense is it's consensual. Are these findings consistent with consensual as opposed to rape? He's going to make that. He's already given them a heads up and saying, hey, you're going to have to look at this very carefully with a fine-tooth comb, because again, there's a difference between rape and consensual sex.
Right, right. And how about this? I want to ask you, but what he was saying was created by the media. It seemed like he was sort of pointing the finger at the media with respect to Jane Doe number 4, Jane Doe number 5. He said after there was news coverage, and these are his words, quote, sure enough, here comes Jane Doe number 4. This is the woman who came forward telling police that she was raped when she was 17 years old. And then with respect to Jane Doe number 5, he said she was, quote unquote, created by the media. This is the woman who said there were 2 instances at her gym. Talk to me about what the jury was maybe doing when they were watching this being said.
Definitely paying attention. A lot of them will look directly at Brian Watkins, but they're looking at the defendant as well, especially to gauge his reaction to some of the things that are being said in the courtroom. And it was significant that Brian Watkins pointed out things that the prosecutor didn't say in his opening statement that they're going to hear from the defense, things that were left out that are important for you to keep in mind as the state presents its case. It's not the full story, basically, is what Brian Watkins was telling this jury, and that's going to raise some eyebrows among this jury, because they're going to want to know the whole story, and they're going to want to know why a man who, like the defense attorney said, was born into privilege and in the spotlight would then turn and commit these very heinous acts.
Most certainly, Shanley, right? And he said just that with respect to Jane Doe number 1 and 2. They're not giving you the whole story, is what he's saying. And he brought up sex for money, too. So perhaps we may see some claims that maybe there was some prostitution going on.
Yes, definitely. And I think that, scoured the court documents and court files, and there's evidence on the defense documents that multiple people's DNA was found in the pants of Jane Doe number 1, that Jane Doe number 2 had a consensual sexual encounter prior to the one she alleges with Winslow. And all of this is going, I'm sure the defense will point to, as he paid for these sexual encounters with these women. They were completely consensual, and because of who he is, that made him a target.
Right. And Chandler, I know you've done a lot of research for Court TV on this case, and something that Brian Watkins said really stood out to me, because this was the first time that I had heard this or anything about it, wondered if you had heard or read anything. But with respect to Jane Doe number 4, he said that when she first came forward, there was one story saying that there were multiple men who digitally penetrated her. Then her second story was one of rape while she was unconscious. Had you ever heard that her story changed?
Yes, that's definitely in the court file and defense documents when they were trying to get that case severed from this trial and make it its own case, because they allege she did, when she first, the defense says, reported last summer to sheriff's deputy what happened to her 15 years ago. She told one story, that's what you said, and then during her preliminary hearing in October of last year, she told a different story, the one that the prosecutor said in his opening statements today. So we can expect that's, the defense's theory here of what you don't hear, what evidence is not there, and they're going to be really picking apart her inconsistencies in her statements, not only that she made, but she has 3 other fresh complaint witnesses. Nikki Edwards, who we heard in the prosecutor's opening, as well as a live-in boyfriend she told shortly after, as well as her now husband, who also tell a little bit of an inconsistent story.
In Chandler, I think what will be really interesting is to hear the testimony from Matt Vaughn. This is someone who is said to be a witness of the alleged rape pertaining to Jane Doe number 4. But he'll be called by the defense, as I understand. Is that right?
He is on the defense's witness list they filed last week. Matt Vaughn is a name that was mentioned by the prosecutor this morning in his opening statement. He also mentioned Chris Resto, who was with Nikki Edwards, the whole group at the night back in 2003 when they were jumping from house party to house party, celebrating graduations. And so, again, the prosecutor, it seemed like he was preempting a lot of the defenses that he knows may be brought up by going ahead and mentioning these names, mentioning their part in the alleged incidents, and then again, of course, the defense is going to call him and see what he has to say, if it's consistent or inconsistent with Jane Doe number 4 story.
Right, Shanley, certainly a tactic to take the sting out ahead of time. I want to ask you, after court recessed for the day, what did you see Kellen Winslow doing? Did you notice anything? I'm just curious if he spoke to anyone in the gallery, and who is there as far as family members of his.
Julie, I did. I hung out a little bit longer just to see what he would do, because during the pretrial hearings, he was able to embrace his father at the end of the court day. Today, the bailiff did not let him. His father hung out a little bit, but his mother was there. His father and mother kind of talked to their family friend that was present in the gallery, and then his mother left. But then Kellen Winslow, when it was his time to leave, he didn't even really acknowledge his father. His father was kind of had his back turned, doing something else. So they didn't get the exchange at the end of this court hearing today.
And as we understand it, Kellen Winslow II's wife is not there today. Is that right?
That's right. She's not there. From what I can tell, the 2 rows reserved for family are made up of some of the defense team's technical people, or maybe a couple of assistants to the defense attorneys. But there's the mother and the father of Kellen Winslow II sitting by each other. And behind them was a friend of Kellen Winslow Sr., perhaps a former football player friend. We're not sure yet, but that was the extent of family there for the opening statements today.
Okay, Chanley, Court TV legal correspondent Chanley Painter, thank you so much for your reporting, Chanley. We're going to take a quick break here on Court TV Live. We'll have more legal analysis for you coming up right after this. Welcome back to Court TV Live. I'm Julie Grant. Thank you so much for being with us. We are closely following the case of the state of California versus Kellen Winslow II, former NFL star being accused of rape and other forms of sexual misconduct. Opening statements just wrapped up by both the prosecution and the defense, and that is all for today. Court is in recess until tomorrow at 9 a.m. And for those of you who may have missed the opening statements or don't know much about this case, we want to get you all caught up now so that you can understand what's going on in this very compelling criminal trial.
This is how fans may remember Kellen Winslow II, a star tight end for the Cleveland Browns, earning millions during his decade-long career in the NFL.
I wanted to be like my dad. Grew up watching my dad's tapes.
Winslow is speaking at his induction ceremony into the University of Miami Sports Hall of Fame. He was a standout in college football, winning the Mackey Award for the best tight end in 2003.
That's the reason I wore 81, because I wanted to be one better than them. I wanted to be one better than my dad.
His father, Kellen Winslow Sr., wore number 80, playing for the then San Diego Chargers. It's clear he had considerable influence on the younger Winslow.
He has one of the most famous fathers in football history. His dad, Kellen Sr., is a Hall of Famer. He carved out his own athletic kind of legacy. So he was known to a lot of people in his own right, but certainly because of his father too.
The playing days for both father and son are behind them. Kellen Winslow Jr. left the league in 2013 after 10 seasons. Today, with his father by his side, he fights a different battle. This one in a courtroom against charges of rape. Winslow faces 5 accusers in this trial. CourtTV is following the court's order that they not be photographed and referred to only as Jane Doe. Jane Doe number 1 is described as a hitchhiker. Prosecutors say Winslow picked her up from this street in Encinitas, California, a few miles from his home. She says he took her to a secluded location where he raped and threatened to kill her if she told police.
I'm gonna f you or I'm gonna kill you. He goes, I don't care who's gonna watch, I'm gonna kill you.
Jane Doe number 2 is a homeless woman. She claims he raped and sodomized her in his car after picking her up from this commuter transit station, also located in Encinitas. A third rape charge stems from an incident in 2003. The woman, 17 and a student at Escondido High School at the time, claims that Winslow, then 19, raped her while she was at a party and unconscious. This picture was taken the same night.
I remember pushing my hands against his studs to tell him to stop.
Testifying at a pretrial hearing, Jane Doe number 4 said she told a friend but did not report the incident to police immediately.
Because I was 17, drinking underage, I just realized who he was. He's gonna be in the NFL. Why would anybody believe me if I had sex with him 2 weeks prior?
Jane Doe number 3, a neighbor, claimed Winslow exposed himself to her. And Jane Doe 5 says she was at the gym when Winslow engaged in lewd behavior that frightened her.
He looked at me so attentively, make sure that we have eye contact. And I was so petrified that I was looking at him.
Is there anything you want to say to your fans out there and everybody that's out there?
Yeah, man, I'm innocent, you know. To the people that know me out there, know what type of person I am. You know, my character, my NFL friends and family, and just my regular friends and family. They know who I am, and I'm an innocent guy. I'm an innocent man.
C.J. Jones is one of Winslow's NFL friends. He was a teammate when they both played for the Cleveland Browns in 2004.
I just don't know the whole story, so it's hard for me to talk about it. But me personally, knowing his dad and what type of player he is, I don't think he did it.
Winslow's attorneys are preparing a vigorous defense, and while it's not clear how they will counter all of the accusers, Winslow believes there is a motive behind some of the claims.
It's a money grab. It's a money grab, and unfortunately, that's the society we live in now.
We don't know where this will head, but at the end, at the very least, he's at risk of losing what a lot of people would be the ultimate American dream.
Right. Welcome back to Court TV Live. What we want to do now is bring back into the conversation defense attorney Patrick McDonough, who is here in the studio with us, and also welcome into the conversation criminal defense attorney David Shapiro, who is standing by live outside of the courthouse in San Diego to join us as well. So David and Patrick, thank you both. Thank you both very much for lending your expertise to us with this trial. David, first question to you, please. I'm curious, have you ever practiced with any of these attorneys on this case?
Yeah, for sure. All three defense attorneys I know personally. I've seen them in court. We've had co-defendant cases throughout the years, throughout my, greater part of the past decade plus as a criminal defense attorney here in San Diego, as well as Mr. Owens, a well-known district attorney in the Vista courthouse, for sure.
Great. And David, we know that Brian Watkins is the lead defense attorney, if you will, on this case. We saw him deliver the opening statement. Can you talk about his style, what you generally see from his in terms of advocacy?
Well, I mean, Brian's an experienced litigator. He's been around for a long time. He's handled very serious cases in the past, and he's certainly in his element defending Mr. Winslow. And certainly we saw a little bit of that during his opening statements earlier this morning.
Mm-hmm. And as far as what we saw, it seems to be a defense of consent that will be raised here. I want to get both of your thoughts. David, go ahead. You first, please.
Sure. Well, what was interesting about the consent offense is, as it relates to Jane Doe 1 and Jane Doe number 2, is, that was a tough decision that the defense team had to make. And my understanding was it wasn't really finalized until the better part of the last week or two. Reason being, once they go with the consent offense, then they had that obstacle of DNA. And by agreeing to consent, you have to basically, to a large degree, say, hey, my client committed adultery. My client was messing around with these women when he had a wife and kids at home, but it was consensual. So you're agreeing to many of the elements, in fact, all of the elements of these offenses, except for the actual act of consent. And what that does is it turns the credibility contest back on to Jane Doe 1 and Jane Doe number 2.
Mm-hmm. And Patrick, I want to turn to you now. It seems that what we may see, what the defense seemed to allude to, was that we may see a defense of consent with respect to Jane Doe number 1, 2, and 4. But then with Jane Doe number 5, the conduct that's being alleged to have occurred at the gym, it seems like we may see a defense of mistake. Do you agree, Patrick?
Yeah, I think that's true, and that's part of the challenge for the defense. They have so many things they're fighting. And I think really they probably made the final decision on the Jane Doe 1 and 2 because of the DNA evidence. Mm-hmm. They had to decide, are we going to fight the science or are we going to embrace the science? They now can embrace the science and just say, yes, the DNA was there, but she was a homeless person and maybe there was money they exchanged hands, and but they don't have to win on the evidence side. They can embrace that. When you get down to 5, it's a little more murky, right? This isn't a forcible rape. This isn't something where someone took him out, behind the highway and attacked somebody. This is somebody who admittedly just saw his picture on the TV camera and has some different inconsistencies and couldn't visually see exactly what was going on. So I think it's a little bit of a different type of defense for number 5.
Sure. And then for Jane Doe number 3, which is the alleged indecent exposure, she is a neighbor. I think what's unclear is whether they're going to present a defense of maybe this was a mistake or maybe this was accidental exposure. I really couldn't tell from what he said. Could you tell your thoughts on what you heard in the defense open?
It was hard for me to figure where he was going on number 3. I think accidental exposure is risky, to accidentally expose. So I think maybe she just made a mistake, or I misidentified the person, or there was something else. I think accidental exposure is a risky defense.
Right, and I'm thinking it may be mistake, just based on the comments he made about saying that the way she identified him wasn't even close to what he looks like, saying she described him as a medium build, and we know Kellen Winslow is a large guy. He's an athlete, 6'4", 240 pounds. So maybe that'll be where we'll go. Right. Okay, but general thoughts as far as effectiveness. I found one of the things to be really effective where Brian Watkins went over to Kellen Winslow II, put his hands on his shoulders, almost in a way of like comforting him in a way, and almost a way of maybe standing by him in a very confident manner to show the jury, this is my client, this is a guy who didn't do what he's accused of doing, and he really owned all those bad acts of infidelity and whatnot. Your thoughts as far as effectiveness? Do you think that was effective for this jury?
I do, and I don't think I've ever defended a case where I haven't done that. It's amazing what cues jurors pick up, and after you talk to jurors after trials happen, and you think it was this, searing cross or this other bit of evidence, and it was the way he acted, or when that picture was up there, he looked this way, or the defense attorney didn't even look like he liked him. So the moment you walk in the door and the jury is seated, you're on. And I thought it was very effective, and it was a smart play.
Mm-hmm. You're right. Jurors are so smart. They pick up on little things. Sometimes it's surprising, the little things they pick up on. As an advocate, if you can have an opportunity to talk to jurors afterward, I always think it's a great idea because you really learn. And you're right. Just going over there to touch him, to put his hands on his shoulders, send a very powerful message. If the prosecution is portraying him as a predator, which they've made statements that he is a serial sexual predator, engaging in predatory behavior, taking from women what didn't belong to him, is what they were saying, and then you see him go over there in a way like that, really send a big message with the body language.
There's no question, and people read body language. People make decisions very quickly based on a feeling. They want to say get a good feeling for someone or they don't, and it's important that the attorney believes in his client, right? And he's not just doing something methodical, but this is a person he believes in, and the fact that his father is behind him and the family is there and that he's part of that, I think it was powerful, and I think it was well played.
Mm-hmm. And something else that Brian Watkins did, he really owned all of that bad behavior, saying there was infidelity. Yes, we're acknowledging it all right now. What he did was wrong, wrong, wrong. Let's take a look at that, and I want to get your thoughts too, please, Patrick. Let's watch.
There's been infidelity in his relationship. Kellen's not proud of it, but he's never denied it. He's been unfaithful. Not once, not twice, but numerous times. I would not dignify these things by calling them affairs, because they weren't. They were sex. No strings attached sex.
All right, and another really powerful thing he said it's wrong, it's immoral, but not illegal. Seems like a big signal as to where they're going to go. Do you agree, Patrick?
I don't think there's any question. And they had to make a serious decision, right? They had to look at the physical evidence. If they believe that the DNA evidence is going to put him there, it's hard to say, hey, this didn't happen if the DNA evidence is there. If they thought they had an ability to attack that, there was a chain of custody problem or a really way to attack that, they might not have gone with this defense. But if they felt like the DNA was going to put him there, they had to own it. And once they own it, of course, they got to own that he's married, right? And it was unfaithful. But what I think they're trying to do is not just own that, but also say, look, we can admit when we do something wrong. We didn't rape anybody. We're admitting this. We're not perfect people. I've made a mistake, and he's going to own the mistake he made. But it wasn't a criminal mistake, right? It was an infidelity mistake.
Exactly. And he mentioned his wife, said they've been together since they were both 13 years old. So these two were sweethearts since they were young teenagers. Made a point to mention they're married. He said that very clearly, they're married. We didn't see his wife there, though, today. She was not there in court. Your thoughts as far as the optics of that?
Well, it's not great, but I will say this. Often that can be really bad, right? Because they're saying, the wife thinks he did it or he's terrible. But here, a wife could still be upset that there was infidelity, but she also doesn't necessarily mean that he committed the crime. It would have been better if she was there. I think the optics would have been better. But I don't think it's the end of the day because of the fact that she could still be upset about the infidelity and not really think that he was guilty.
Sure, not really going to make or break things.
Right.
And it's still early, obviously. We're just seeing the opens today. Right. So perhaps tomorrow, being that it'll be a lengthier day with more testimony expected, maybe we'll see her. But one thing that's been constant, though, is Kellen Winslow Sr., the dad, NFL Hall of Famer, former San Diego Charger. I mean, been there through everything, every single court event he's been there. What do you think that says to the jury? When obviously they're watching, you just pointed out, they're so perceptive. They're going to be looking in the back, going to be noticing. Your thoughts on those optics?
It's important. I mean, the reality is people look for that, right? Is he really someone who comes to this family? And from my understanding, he's loved out there. The family and the father, and obviously he was a famous football star as well. So it's important the families coming together, that this doesn't make sense. There's something illogical about this. Someone who has $40 million, that has a loving family. Why would he go, rape someone like that? It doesn't make logical sense. So I think those optics are important. It's important that the attorney embrace them. It's important that the father's there. It'd have been better if the wife was there, but I don't know that it's a deal breaker.
Sure, Patrick. And the prosecutor, he really seemed to acknowledge right out of the gate that this is somebody with a very famous father. He's very famous, really took that sting out, wanted to remove the celebrity status. Let's take a look back at a clip from Deputy District Attorney Dan Owen's opening statement. This was in regards to Jane Doe number 2 and what allegedly happened to her. We do want to warn you, what you're about to hear is quite graphic.
The defendant grabbed her neck with both his hands and choked her and told her, "If you scream, I will kill you." You're going to hear that she at first couldn't breathe. He grabbed her so hard by the neck. She finally said back to him, "If you don't hurt me, I won't scream." So he released her neck and continued to rape her. That he raped her until he stopped and ejaculated into the dirt alongside of her.
All right, so talking about the strangulation, the forcible rape there. Patrick, what I noticed from the defense opening statement was that he said there's really going to be a lack of evidence showing these physical injuries to prove that nothing more than consensual sex occurred.
Right.
Your thoughts on that?
Huge. I think that's critically important, right? Because now you're trying to take the physical evidence as the defense team and take it to your advantage. You've already taken DNA out. You've said, okay, this is consensual. But now they're painting this picture of this horrific rape where there's choking involved, right? And she reports the next day. So if she's getting choked and physically accosted like we all see on TV in these terrible scenes, then why isn't there a mark there? Why isn't there something that would corroborate that? And if there's not there, then it brings into question, well, maybe there's something wrong with this story. So I think that's very powerful for the defense.
Patrick McDonough, criminal defense attorney, former district attorney. Always great to have you here. Thank you so much for being with us here today. Also want to say thank you very much to David Shapiro, criminal defense attorney, who's out in San Diego and talking with us live. David, thank you as well.